So I'm just going to start just with 2 or 3 minutes to set up the afternoon and this panel and the next, but I'm not going to take a lot of time. You've already heard too much from me. So this afternoon we really are, I think, shifting from regulation to law. Now I know regulation is based on law, but law in the courts. And so this panel is going to be looking at the interpretation of insurance policies, as well as the role, or the potential role for courts as regulators, if that's appropriate or not, and that's obviously an issue. And then the final panel will be shifting to thinking about whether or not or how to embark on a new ALI project looking at first-party insurance that would nest with the liability insurance project. So that's the basic approach. And I think rather than me spending time talking, I'm just going to turn it right over to the panelists so that we hopefully run a bit on time and have enough time for questions. So I will start by turning over to Omri Ben-Shahar.
processes. This is not an ideal way to get to the solution. So the solution is use data. And then I'm going to talk about two primary methods that I would like to suggest. Again, not currently used. This is ideas for exploration. One is based on a recent paper that I wrote with yours a little bit to use large surveys, and the other is based on a BYU student paper that I think is fascinating, and that is to use big linguistic data sources and tools. And I'll explain briefly each one. But I'll use examples for one example for each. So surveys. Take the following sentence, the typical exclusion for business, the business pursuits exclusion. This is from the homeowner's policy. Does not apply to bodily injury that arising out of business pursuits, blah, 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 blah. What about babysitting? Does it apply or not? Well, the insurance law experts in the room will correct me if I'm misstating. Is that okay without this? Will correct me if I'm misstating the landscape in one sense, but I think that courts disagree on that. Divided. Some say that the exclusion applies because the business babysitting is for money, and it's a business, it's a type of a small home business. Others say that the exception to the exclusion activities incidental to the business, to non-business pursuits should apply, so the exclusion doesn't apply and the policyholder win. And others say, well, it's a kind of ambiguous, we're not sure, so apply contra proferentum. Can we do something more definitive? Can we get maybe a null result, that it's ambiguous, but not because the judges say, oh, courts disagree, but because people will actually say one thing or another. So we put this example based on one of the case, the Moore versus State Farm case that is in Kyle and Tom Baker's casebook, to a representative sample of consumers and asked them whether the exclusion would apply. We showed them not just the original exclusion language, but also a shortened and simplified one without the except component, and they got results. Now, I can show you the results, but the point is that that's the method. Ask people. If you have a dispute, it cost us $3,000 to do. And this is, people were asked to say if it's surely covered, probably covered, surely not covered, or don't know. And we've done this on many cases. This is one example. We've realized that people will never get 100 to 0. You have to figure out, develop methods, which are, by the way, a footnote, have been long developed in the area of unfair competition. For me, the inspiration for this project was from teaching trademarks and unfair competition and seeing that when there is a dispute about what a message, commercial or language means, you go and do surveys very successfully. Today, you can't go to litigation in this area, interpretation of pre-contractual communications without a survey. Why not use it also for contractual disputes? The summary of it is that, just to see that particular example, the original exclusion, well, the insurer won, but not by a landslide. 46% to 36%. Maybe not enough to defeat a kind of a presumption against the drafter, namely, you could have done better. For example, by using the simplified version, where you get more than 2-to-1 ratio, it's hard to get in these surveys more than 2/3. There will always be 15% that will say, if you ask them, will the sun rise tomorrow, they will say no. So 15%, according to our experience, is the new 0, and everything has to be normalized to that. 58% is fairly resounding majority, and that would spell a victory. And by the way, the insurer can pretest, and Michelle will talk about it. In fact, she thought about these things before we did in a very creative way. Can pretest the language to make sure that they can get court victories on interpretation battles. So that's one example. That's one method, the survey method. The other one is based on this other paper, and that uses linguistic database analysis. So take the liability policy that excludes, the insurance does not apply to bodily injury that arises from participating in any sports or athletic contest. Okay? What about snorkeling? Is that a sport? It also comes from, a leading case, a Massachusetts case, and the court how did the court resolve it? Well, they opened the dictionary. And it is not clear, the court said, that snorkeling falls within the plain meaning of sports. Why? Because dictionaries actually have two meanings. One is rule-based athletic competition. Snorkeling is not a rule-based athletic competition. You just swim, and snorkel. The other is physical activity that gives enjoyment and recreation. It does fall into that, but there are two dictionary interpretations. Therefore, it's ambiguous, and the interpretation is against the insurer, namely, the exclusion does not apply. It is possible that snorkeling is a rule-based athletic competition, therefore it does not apply. Now, it turns out, and this is all based, by the way, I really want to give credit where it's due. This is, I've learned about this method from reading a student paper, now it's a work in progress. A BYU student by the name of Stephen Moritzen wrote as a student a paper on statutory interpretation using linguistic analysis and showed how a particular very important case that the Supreme Court was then deciding based on statutory could be, at least we can get some important information on what the word means, the textual analysis means, based on linguistic analysis. I'll try to explain in a minute how it is done. And now he has extended it also. He wrote a paper. He then clerked for the Justice Tom Lee of the Utah Supreme Court, and together they used the same methodology, persuaded the judge to use it in cases, and the Utah Supreme Court is using this data-based method for interpretation of statutes. They wrote a paper that just came out in the Yellow Journal about constitutional interpretation. But the interesting thing is that it can apply, and he has a work in progress paper on how to apply to contract interpretation and how to effectuate the plain meaning rule through this method. And this is one of the examples that he shows. I just took it from his paper. We see that snorkeling is used colloquially and commonly as referred to many things, like, for example, sport that can be enjoyed even at old ages. So that means that's not necessarily rule-based athletic competition. A search, if you look at the corpus of the contemporary American English, 500 million words, very large database of text, you can see that you can tell that database to look just like we do Lexis search. Put in the word sport, and it'll give you all the results. And then ask all sorts of things. For example, what are the most common words that appear next to it? Within 10 words of it, or something like this, and how many of them are related to competition versus recreation. That's exactly what Mr. Moritzen did, and you see here are among the list of the top, or partial list of the top 100 words that are most often come up in association with, or in adjacent to sport. Many of them you can see immediately just by eyeballing them have to do more with competition than with recreation. Ultimately, there is some discretion here in the analysis. You look at each one of them. You can go back to the text where they are, what they are referring to, and ask yourself, are they referring to meaning one or meaning two? And according to his analysis, 3 out of the 100 unambiguously suggest sport as a recreational activity. The vast majority refer to sport as competition. And if we have this ratio of 9-1, or whatever it is, 97-3, then we go with the majority, with a clear majority. Here, the clear majority is sport is an athletic competition. Therefore, snorkeling is not a sport. Therefore, the exclusion to the exception to the exclusion does not apply, but the insurance company loses, but not because of ambiguity. They lose because their meaning is not the plain meaning. There is a plain meaning here. We've just figured it out not by looking at dictionaries, those not telling us anything quantitative, but rather by looking at this data. So that's the second method. There are, I would suggest, many other possible data-driven ways to interpret contracts and insurance contracts, but to try to figure out what the plain meaning rule. Not every time that we see two possible dictionary meanings, there is ambiguity. Many times there is no ambiguity. We just have to have the right tools to tease out the common meaning. Ask people or ask texts. These are the two methods that I suggested here. And finally, I think this kind of, just to talk in 30 seconds about the advantages, it does, I think, enforce the meaning that people expect. This is positive law. The law tells courts enforce the meaning that people expect, as the mass of mankind would view it. And that's what we're getting through these methods. It's inexpensive. Morrison did his search in probably one afternoon. Strohilovitz and I did it for $3,000. It does not involve the same kind of legal battles that are very expensive. It might induce simpler drafting. You know now, as a drafter of a text of an insurance policy, that you will need to win these battles that are fought over in the retail world, not in the expert world and not in courts. It might reduce interpretation risk because these things can be pre-tested and predicted. And it also will do something, I think, that is time we stop doing, at least in academia, which is what is known as normative interpretation. Interpret contracts so as to accomplish greater good for society. There's a lot of room for rules that do good, but they cannot be masqueraded as interpretation. They should not be masqueraded as interpretation. They should override interpretation sometimes if there is a greater good to achieve. But so these are the things that so I guess I'm going to stop here. What is the future of contract or insurance interpretation? Data-driven or legal work? And I vote for the left-hand side. Thank you.
Next, we have Jeff Stempel and Erik Knutsen. And unlike our other panels, no, this was not planned. I independently asked them to, and then they decided to write a paper together. So they are going to be doing a joint presentation.
Where's the clicker? Where did our clicker go? There we go. There's our clicker go. Well, good afternoon, everybody. You get two for the price of one here. Dan's right. He asked us separately, and then we said, hey, can we just tag team? You may not know it, but Jeff and I are brothers. I'm the older one. First off, let me say to Dan, thanks. You plan a heck of a wedding. And what a remarkable bunch of people here, and so many that we all know. It's a great event. All right, so my co-author and I, Jeff, are going to hand off at various parts as we go. We're going to talk about rejecting word worship. That's our title, an integrative approach to construction. And so first off, we want to talk about the meaning of the word policing versus construction. Because this is a panel about courts and the policing of insurance, we just wanted to sort of tease out two possible meanings we think for policing. Concept one and concept two. Concept one for us is just sort of outright prohibition or mandated provisions in an insurance policy. But concept two, or sort of the softer policing model, is when courts provide a construction of a policy consistent with the parameters of what that risk-based instrument really is. And so as we chat, you'll sort of see how we draw on either concept one or concept two. Why and how can courts police? Whatever the branch of government, even if it isn't courts. Well, you often will hear, and we have some issue, I think, my co-author and I, with the idea of freedom of contract trumping policing. My colleague and co-author will talk more about that. But for us, if a party is looking to enforce an agreement and turns to the state for help, and if that agreement is a contract that the rules of the game or the rule of law says the state can help you enforce that, then I think we're okay with the idea that the state's entitled to determine whether it can enforce that contract or not. We don't think that's a radical thought, by the way. There's well-established grounds of refusing enforcement based on things in contract that we can remember, like illegality, conscionability, or good heavens, even public policy. Well, what do we mean by contract? We actually mean the agreement that the parties came to, not the writing of it, not the words themselves per se, because to us the writing is just a memorialization of a deal. So in insurance, the agreement's about risk transfer. We've got some written stuff there that helps us figure out the parameters of some of that agreement, but it's really just the memorialization of it. That's a different problem in an adhesionary context like you have in insurance. So to us then, insurance policies really are more like products as much as contracts. And to this we owe a great debt and a big nod to our friend and celebrant today, Dan Schwarcz, who has absolutely groundbreaking work in this particular area, insurance as a product. And Dan, we agree. We think you're on to something here. So when you take a look at what we're thinking a contract/policy, and I think we prefer the term policy when we talk about insurance. Sounds like a contract on steroids, right? It's a little more fun. When we take a look at how the role of policing of insurance policies or insurance contracts happens, and you look at Concept 1 and Concept 2, Concept 1 may be best done by the policy-making branches, although you could do it in courts. But Concept 2 to us is best done by courts, that interpretive exercise. It's a little more flexible, a little better to get at the actual dispute going on in the words. So I'm going to hand the mic over to my colleague here.
We'll see if this actually works, trying to master the technology on the fly here. Fortunately, it's not too complex. So we're proposing essentially, and we freely admit that we're not trying to do anything all that radical. We certainly have roots in the contextual approach of the second restatement, or the what we call the Thomas Dreyage case from the Justice Traynor wrote in California about taking a hospitable approach to extrinsic evidence as well. And what we're going to then propose here is a quick template that sort of draws upon that in a more stylized form, and we think that should be the first role of courts, is the soft policing, policing number 2, try to get the result that actually makes sense to vindicate the objective of the transaction, or the policy, or the contract, if we want to call it that. And then at that point, of course, you do a check with the stronger version of policing, number 1, version 1, about whether something is illegal, unconscionable, or in some ways violates some other clear public policy. So our pitch is that contracts need more tools. We realize we're running against the grain of the most recent revisions to Section 3 of the Restatement of the Law of Liability Insurance, but we are distressed at the idea that things be so exclusively text-based and that there be resistance to looking at other tools unless one finds a facial ambiguity. Text, in our view, should only be one tool for meaning, and that the real role of courts in the soft policing context should be giving effect to the instrument as it's supposed to work in the grander scheme of its context and setting. And we think if you're just focusing on text, you can get some bizarre results that occasionally get saved by the absurd result canon, but not always. Problems with textualism. Words are not clear. We just had a wonderful exposition on that. 50% is the new zero. It's hard to get more than 2/3. And certainly insurance policies we all know are not read completely. Standardized contracts are not read. Insurance, we think, is even more problematic. Even if you wanted to read your insurance policy, it doesn't come until after you've placed it. Think of the inertia there if you suddenly decide you don't like your endorsement number 13 of your policy that may or may not have been discussed about. Text can be inaccurate. We also subscribe, consistent with our view, that talking about reforming the contract is really inaccurate. You're really reforming the defective memorialization of a contract if the language is incorrect. You're not reforming it. It's just a scrivener's error, and it's not really reflecting the contract. Obviously, and our view is more, Mies van der Rohe notwithstanding, that text alone is in isolation can be misleading. More information will give more data, and textual reading should use extrinsic evidence. As I've said, it's not a revolutionary concept, it's a broad approach, but I think what distinguishes our viewpoint on it is we're trying to be more purposive, and we're running away from the idea that the words are the contract. The words are the expression of a transaction, a deal, an arrangement, an object, a purpose. So our template in brief will look a lot like a Thomas Dreyage or a Restatement Second template, but I think the key point is to cite the objective right from the start. Rather than saying we begin with the words of the contract. No. We should begin with the object and the purpose of the transaction so that we can better understand the words of the memorialization of that particular arrangement. Then, of course, you read the policy documents in light of that background as a whole. And canons of construction and Carl Llewellyn notstanding, we think they should be considered with no single factor necessarily determinative. Consider extrinsic evidence if it's proffered regarding party intent understanding. Obviously, if there's correspondence that outlines what people were expecting, illustrative examples that people had in their mind, that would all be relevant. Identity of the policy is something other than a contract. Our contract is product or private legislation or instruments serving a socioeconomic purpose as well. Sometimes consider actually the word meaning and certainly the substantive elements of the canons of construction, and along that line, something like construing exclusions strictly and construing coverage grants more broadly would be of that type as well. And of course, you've got to do the policing for illegality and problems like that might arise as well. Now, we think the key to this approach is going to be realizing that it's a continuum because, and I'm already beginning to intrude on Erik's thought process a little bit on this, which is that there will be an objection, and we've heard it before about, well, now you're going to make every case a federal case. I use that term as advisedly as an expression. There's going to be all this weighing, et cetera. No. We think that some cases are going to be easy because all of the other available indicia of meaning will align with the text, or there'll be a widely accepted, or there'll be a historically established meaning of text. So we don't have to reinvent the wheel for every contracts or every insurance policy construction battle. We might want to spend some time building the wheel on the more difficult cases, the more novel cases as well. And because we have an adversary system, ultimately this will not have to be sua sponte heavy lifting by the courts in their policing role. They will be responding to the proffer of other indicia of meaning and other factors regarding purpose and background and intent. And if there aren't any, then it does become that sort of easy case where we give language the most natural meaning in light of the context in which it's abiding. I'll give it back to Erik for a few minutes.
So, what are some problems with this idea? Well, some of the challenges that we sort of thought of, logistical is one. We've got a few steps in a list there, but as Jeff just mentioned, you could ramp it up or ramp it down, depending on what the case called for. As long as your focus is on the risk management aspect of the policy as a memorialization of that transfer, however much or little of the model you need, I think would be fine. The main concern we sort of anticipate was, well, gee, aren't you just throwing out the text? And I suppose that may be thought of as fair until you stopped and asked yourself, well, if the policy text is so clear, then shouldn't other indicia of meaning also align with that meaning of what you think the text is? And then everything's fine. And if it doesn't, wouldn't you like to know? Judicial restraint. Well, we also think we've got some good evidence in cases that the textual approach to interpretation doesn't exactly rein in judges any more than a more purposive approach would do. And finally, I guess, I'm the token Canadian in the audience, and Jeff is from Minnesota, and so we're just trying to be two helpful folks here to the bench. And even though one of us says about instead of about, it's still... when you break it right down, our point is to at least let judges be something more than linguists. There's nothing special about the operation of judging that means you're great at parsing language. We actually think they'd be pretty darn good at parsing sociological evidence, actuarial evidence, underwriting evidence, you name it. There's nothing special about reading words. Finally, whatever we're proposing here, as Jeff has mentioned, is coming from a lineage of something. It's not brand new, from Thomas Drage, and a nod to the restatement second of contracts. And finally, to the restatement of the law of liability insurance, which initially adopted sort of this kind of approach, and then Jeff has sort of mentioned backed away somewhat. So that's our idea. It's an integrative approach. We're ready to pass the torch on to Michelle.
Excellent. Well, I'm going to sit, so I invite my fellow panelists to come join me, unless you want to stare at me from there. Come back. Yeah, we have some disagreements, but we're all a friendly group, right? Okay. So I'm going to talk about, in the end, what's going to be very synergistic, I think, with the rest of the panel, although it might not seem so at first. I'm going to talk about the difference between interpretation, which I think is the comparative advantage of courts, and content regulation of policies, which I think is the comparative advantage of regulators. Maybe legislators, but in this case, I'm envisioning kind of state regulators. And this is a continuum, right? It's the difference between interpretation, construction, content regulation, we know is not binary. It's not always easily divisible, as I think the work that we just watched shows. But I'm going to starting from my own work in interpretation, I'm going to talk about two circumstances where courts struggle with interpretation, and ways in which it might be that state regulators could step in and do a better job. Now, this is a dangerous thing for me to suggest, because first of all, I teach at the Scalia School of Law at George Mason University, and I'm proposing more regulation, which is something I have never done, and I think none of my other colleagues have ever done, but I have tenure, so I think it's okay. And secondly, I know a lot about interpretation. I might be wrong, but I know a lot about it. But I know not as much as everyone in this room about state regulation. I think it's okay because what I'm suggesting as a possible role for state regulators, I know is not factually impossible. You may come and tell me that the money for it isn't there. That I would buy. Okay, so the two interpretive problems I'm going to talk about are these. So first, is courts applying tools that are meant to deal with ambiguity to circumstances that aren't ambiguous, but are instead complex and I will say kind of unsimplifiable, which is to say they're not understood by policyholders and they never will be. Right? I don't know how clearly you can write your explanation of string theory, but there's a large proportion of the population that will never understand it. And I propose that there are certain insurance terms or clauses or provisions that fall into this category that are beneficial to policyholders, but incomprehensible in any kind of written form, and we have to decide what to do with those. Right now, courts tend to treat them as ambiguous, and I'll talk about that in a second. The other category I want to talk about is handling claims about ambiguity, consumer expectations under the reasonable expectation doctrine for jurisdictions that have that possibility without much in the way of useful evidence. And this is a place where Omri and I have work that overlap. So in 2010, I wrote an article suggesting, partially as a thought experiment, this idea of the tested language defense. And I wasn't writing so much about how we would do the testing, right? I was kind of envisioning surveys. Everything Omri's been doing takes us well beyond that. But I was partially trying to figure out what courts would do if they had evidence about ambiguity other than the kind of natural evidence we think they have now, which is, Omri gave us some of it, and there are implications from Jeff and Erik's work about this. So what do we do? What would judges do with more information? And so part of what I was curious about in that sense is just the goal of clarifying what we mean by ambiguity and what it looks like in the real world. And I'm a little disturbed that Omri's outcome is even worse than I expected. So I thought 10% of people think that Elvis is alive. Right? Actually, it's gone down to 7%, so we've made progress. But I was of the view that 10% of people believe anything, or at least they'll say anything. But I do wonder what courts think counts as ambiguity. And I think what's disturbing about what Omri shows is, I think that most courts would say 60-30 is ambiguous, right? You don't have to be 50-50 to be ambiguous. 60-30 means there are two plausible meanings. Now, maybe I'm wrong about that, but I think 60-30, for a lot of courts, that counts it as ambiguous. And we have other things we can ask. So is 80-20 ambiguous? What if the 20 is just a ridiculous view, right? The people who believe the 20 are the people who believe Elvis is alive, right? I don't know. But if it turns out that we end up with this evidence either in court or before the state regulators, and we discover that the best you can do for language understanding with consumers in, let's say, homeowners policies is 65%. What does that mean for all of our ambiguity jurisprudence? I'm not sure, but it means a revolution. Okay, the other thing about this that I was interested about is what do we do with the evidence, if there is any, of the policyholder's interpretation or their reasonable expectations? And for this, I would also love evidence. How does the court conclude that the policyholder reasonably expected coverage? I mean, there really isn't any evidence, right? It's the court's conception about what the policyholder would expect given the nature of the policy and the risk being conferred and so forth. And the court could be right. But I mean, we're really flying blind here. So here's going back to the regulation portion of this, because I'm going to run out of time at some point, is that sometimes the court's motivation is to mandate coverage, which to me is a regulatory function. And I think it goes a lot like this. Here's the primary reason. So the court's position is policyholders expect this coverage. They believe it is part and parcel of the thing they have been sold, and there's no way to disabuse them of the idea that it's part of that parcel. They're not going to be dissuaded, least of all by confusing language that requires you to read 3 different sections of a policy, right? And so the court says, or wants to say to the insurance company in the litigation, you just can't have this exclusion because the policyholders believe they get this, so you should give it to them. You should sell to them what they're buying, right, is the answer. Now, I'm actually completely open to that, even though I may worship at the temple of the text to some extent, but it's a regulatory function, right? And what worries me in part as someone who cares about interpretation is that when courts do it under the guise of often contra preferendum, saying that the language is ambiguous, or if it's reasonable expectations, actually, strangely enough, I'm warming up to reasonable expectations, you'll be shocked to know. Because at least it's not messing with the use of contra preferendum. And it seems to me that when you use contra preferendum in places where the text isn't ambiguous, you create various problems, including, imagine for the moment that the court is wrong. The policyholder before it wants coverage now, obviously they've had the loss, but let's assume the mass of policyholders don't, right? If the court mandates the coverage, based on the court's own inclination about what policyholders want, then now all other policyholders have been forced to take the coverage and pay for it. And the insurance company has been given a false redraft signal, which the court can't actually say to them, you can't have this. So instead, the court says it's ambiguous redraft. But that's not really the message they mean to say. It's fake news, right? It's the fake redraft signal. And so the insurance company, I think insurance companies can be quite sophisticated about this. So maybe they don't redraft because they know that's not the real signal. But then we have quite a gap between what the policy means when it's enforced in court and what it means when you read it. And that seems to me to be a disservice to policyholders. Okay, so what about the other category I'm referring to, which is what I'm going to call a blank hole based on Stephen Choi, Mithu Galati, and Bob Scott have work about what they call black holes in contract interpretation based on the pari passu clause, which I don't have time to discuss. But I have this conception of blank holes in insurance contracts. So a black hole is a variation on language that gets used repeatedly that neither party knows what it means, but it just always shows up in that kind of agreement. And they have examples of that in their work. A blank hole, to my mind, is a contract provision or the integration of 2 provisions that has clear meaning to the lawyers and clear meaning to the judges. So anyone with access to precedents and a little bit of legal knowledge can readily figure out what the meaning is. But it's not that it has a second meaning to the policyholder and therefore is ambiguous. It has no meaning. It's an empty hole in the policy. And courts tend to treat these as ambiguous as well. And I think there are downsides to that, right? Now, it might be that we should change the rule of contra preferendum. It might be the rule should not be if ambiguous, then construe against the drafter. Maybe the rule should be if confusing, then construe against the drafter. But it's a different set of incentives, and I think we need to think clearly about whether or not that's what we want to do. To me, the biggest problem is that we might have this unhelpful treatment of provisions that are naturally, inherently complex, but as I said before, benefit the policyholder. So if you envision, and this is going to rankle some people because I don't know if everyone would agree that this is potentially a good thing, but if you envision ensuing loss provisions, right, which make no sense mostly to law professors unless they've looked at them recently, right? 5 weeks later, we can't tell you what they do. But if you stare at it, you look at the precedents, eventually you figure out what they do. And they do something good in a lot of cases, right? And so I think part of what we can have is the kind of structural ambiguity that various people in this room have referred to in their work, and that is you have the grant of coverage obviously other provisions, then an exclusion, then an exception to the exclusion. And the exception to the exclusion is a benefit to the policyholder. But the exception to the exclusion, which in many ways is what an ensuing loss provision is confusing, especially structurally. And I think for a lot of policyholders, the ensuing loss provision has no meaning. But if we tell insurance companies that means it gets used against you in ways that the court knows was not intended, maybe they'll just take it out. Right? You're fine, we'll just have an exclusion altogether. No exception that benefits the policyholder, let's just get rid of it. And so I am worried that if we treat inherently complex provisions that can't be made more clear to policyholders as ambiguous, we punish insurers for using them, and policyholders lose something that they want, even if they can't understand it in the way that we write it. And referring back very briefly to the evidentiary question, it would be interesting to show, what I suggested in the tested language defense was possibly a safe harbor for an insurance company, where the insurer could say, look, we tried to rewrite this provision 4 different times. So we tried it out on Amazon Turk, and we have 5,000 readers, and the best we could do is 50% of people understood this language. Right? And the court still might say, or maybe then the state regulator would say, too bad, it's a contract, the words have meaning, you can't have it. Or the court might say, well, we think actually this is to the policyholder's benefit, and we don't want to use the redraft incentive portion of contra preferendum because what you've done is already done the work and this is the best you can do, and maybe we'll look at corporate liquidity or something else and accept that despite the fact that contra preferendum as it works now might tell us to get rid of it, we don't want to get rid of it. Okay, so very quickly, what's my then regulatory suggestion? This is maybe shocking to some people, maybe not. I think it might be that we should say that we have this regulatory rule that if the state Supreme Court finds language ambiguous, right? They found it ambiguous in contra preferendum and they construe it against the insurance company. We could have a rule that says the insurance company has, pick a period of time, 3 years to redraft it. And at the end of that period, if they haven't redrafted, they can't keep using it. And at the same time, the state regulator has that same period of time to decide if what they're looking at is an inherently complex term that is of benefit to policyholders. And then the state insurance commissioner can actually suggest language or issue some kind of ruling that courts could understand that says something to the effect of, this is to the benefit of policyholders, this is the best they can do, stop construing it against the insurance company on the basis of ambiguity.
Great. So we have some time for questions. I actually want to take moderator's privilege to ask the first question, because one of the things that has always bothered me about insurance interpretation is the lack of clarity about what the purpose is. And I think that there are a number of different purposes that we heard throughout these conversations. I just want to try to make it explicit. One important purpose of insurance interpretation is to make the policy text clearer, to give an incentive for the policy text to be clearer. And there are a number of different reasons why we might want to do that. One is so that when you're purchasing coverage, you know what you're purchasing. But most of us know that when you're purchasing coverage, you're not looking at the contract. I would submit that the more important set of reasons to make the insurance policy language clear is that so when you file a claim, you know whether or not it's covered, and if it's denied, you can assess reasonably whether or not the denial is valid. And second, to facilitate the actual review by regulators and by other third parties, market intermediaries of the text, so that they can publicize and mark out and prohibit text that's not clear. If we accept those as being one of the predominant sets of goals of interpretation, to make the text clear so you know whether or not the claim is covered, and to make it clear so that experts essentially can interpret it, we should favor interpretive tools that tend to reward specificity even if it comes along with complexity. And I wonder, Omri, I guess this is really to some extent for you, if that is the goal, then maybe it shouldn't matter what ordinary people think. Maybe we should be doing surveys of regulators, or maybe we should be doing surveys of insurance experts. So how do we figure out, if one, does that make sense to you? I mean, and two, if it does, how do we figure out who we should be surveying and asking these questions to in order to interpret?
You know, I think that the question is sometimes primarily legal. Who is the contract written to? if you think that some contracts are not insurance in the general area, in my general treatment of the problem, I looked also at commercial contract, merchant contracts, and I thought in these contexts you don't survey Amazon Turk respondents, but you find the right sophisticated merchants that have no interest in the case to survey. I kind of think that the law says that an insurance contract, retail contract, is written has to be. I know that the law says, I think I know that the law says that because it's written for people, it's what people think it means, not what regulator think it means. And I think that it's the question whether this could have been written and how to get insurers to write it more clearly, which is a normative concern, how to have a better world in which they write better contracts, not the world we are in, could be addressed in this context by using, within the survey method, using an experimental method, showing the respondents not only the language that they saw and seeing whether it's 60-40 or not, but showing them additional language that gets the insurer the same result, but could have been understood by people to mean that result, not 51-49, but 60-40 or 65-35 or something like this. That's a reason to apply contra proferentum, not some a priori notions about what is a majority. If I may, I want to touch on that because Michelle said she thought until now that 60-30, 60-40 is ambiguous.
By the way, I can do math. The 60-30 is taking out the random 10%. I understand that 60-30 is 90.
Whatever number, and some people nodded, and I thought to myself, but based on what? How do you know what is a strong majority? Like 60-40 in a presidential election, we will say is a landslide. Yet somehow we sometimes feel that maybe it's not such a big majority in other contexts. I think we don't have an empirical sense of what it means to write something clearly so that people will understand it. We have maybe this something in mind, 100% of the people will understand it. We'll never get to that. I think what we need to do in order to figure out what is the right benchmark for a strong majority is to take cases in which we think that the language is overwhelmingly clear. The contract refers to dollars. Well, is it US dollars or Canadian dollars? It refers to flood. Is it flood of water or flood of locust? I don't know, And take easy cases and do a few surveys on them and see what you get. And you'll get, I would say, 80-20. And that's why I said, you can't get more than 80. Now, if you got 60%, that's a long way towards the 80% that is the maximum. It starts to look like a very strong majority. In that sense, I think what I guess I'm saying is that we need to set aside these old benchmarks that are kind of mythological benchmarks, that are related to no true empirical anchor, and try to create empirical benchmarks for what it is that we would constitute as clear meaning.
So it's a very interesting panel. I'm enjoying it a lot. But I just wanted to throw out there, we have an old-fashioned institution of panel experts who interpret things that you put before them and make decisions on legal matters. We've called that a jury, for a very, very long time. So my question is, at this point, if there is such diversion, why don't we simply move this to a question of fact? I also teach commercial law in the Uniform Commercial Code, or have a hearing on the interpretation under the circumstances, question of fact for the jury. We have the legitimacy of the process, of that, and familiarity for everyone. And I think, and it's a panel that most of us, if we believe in our democratic norms, respect.
So if I could just say briefly, part of that is appealing to me. I think a jury would do a better job at guessing at the reasonable expectations of the average policyholder than the judge, for example, right? So if we had that as a doctrine. But there are lots of problems it doesn't solve. So the problem of, a jury looks at evidence in the same way that a judge does, right? So we still need better evidence, and part of what Omri is proposing to us is a different kind of evidence. But the jury also needs to have the law as stated by the judge. In response to what Omri just said a moment ago, I think that when judges realize that 80-20 is the best you can do and that the vast majority of the contract is 60-30 with 10% doing something crazy, they're going to have to say, okay, we understand we're not going to declare all of this ambiguous, so we're not going to say to the jury contra preferendum, but we are going to have to say things like, all right, the rule still is that even if the policyholder's interpretation isn't as strong as the insurer's, which I think actually is the rule, as long as it's plausible, then we apply ambiguity. So a lot of these problems aren't quite solved by having the jury. You still have to give the jury the clear rule, whatever it is, and you have to give them whatever evidence you decide is appropriate.
Right, no, of course, I understand that, but we could easily move to, we have terms for that also. It's called preponderance of the evidence.
So let's see if we can get a few more questions in for, so, quick, but
Real
let's.
quick. Frankly, in Omri's work, Erik and I have the view, since we don't think the contract is something other than the text, it would be better to ask people, when you buy a homeowner's policy, do you expect to get coverage for A, B, and C? And there I bet we'd get much stronger data, and it would probably surprise people. I think they expect to get coverage for a flood, right, or expect to get coverage for this and that. And again, that should be another data point to consider. This is a little far-field, but I think you're onto something in that there's been this effort to try to make everything more refined and can be judged in a judge's chamber. I'm reading the text. Contract interpretation is a matter of law. We've made official immunity whether there's a violation of clearly established law, not whether there was good faith on the part of the officer. We've decided that the judge can decide whether a claim is probable at the Rule 12b6 stage, and I think that's all wrapped up to something which at least some of us think is a negative.
Okay, so I want to take a few more quick questions, quick answers, so that we can get on. But Brian?
Yeah, as a recovering literary theorist, let me say that I'm very skeptical of the corpus theory of Mr. Moritzon's theory. So for one, the selection of the corpus to begin with is normative. Even your discussion with Dan revealed that. It's especially a problem in the constitutional context, but still happens with contemporary language, which is the corpus that tells us the meaning that we think is the relevant one to this contract. More generally, I think you want to think about techniques for reducing opportunities for p-hacking. There are so many different aspects of the coding that are manipulable. At a minimum, I would think you would want to pre-register what your technique is before you begin a linguistic analysis, those kinds of things. But it's an intriguing path, so let's think about how to develop it so maybe it can answer some of these critiques.
Are there other questions? Oh, yeah. Can you introduce yourself?
Yeah, Peter Sampson, retired. I'm curious whether, to all the panelists, whether you've considered how these things are actually bought. And I'm thinking about the analogous world of the securities industry, where the laws are written in such a way that everyone understands nobody reads the 34 Act disclosure, nobody reads the prospectus, you don't get it till after you bought the security. There's this intermediary group of brokers and so forth and analysts that do the reading for you. And in the insurance world, there's an analogy to that, because you really buy from a broker or a salesman whose job it is to digest this for you. And it's his or her description that you're relying on, not what's in the contract.
Let me just say really fast, I agree with Dan that there are places where the language matters. We know it's not like right when you get it. I think that one overlooked place is being able to judge your insurer and affect a reputational effect in the marketplace by looking at the language after your loss and deciding, if you can for yourself, whether or not they are treating you fairly. The clearer the language, lots of cases maybe it'll be hard, but the clearer the language, the more we'll have any hope of consumers being able to judge the behavior of their insurer.
There's actually an interesting point, simply because Jeff and I often talk about any of this language only becoming relevant after you have a mess in front of you. It's tough to picture the relevance of language of flood or babysitting and liability until you babysat and had a problem, or you got water on the floor, on the front end. But that being said, part of our integrative approach at the front end and asking, what is this risk management tool supposed to be doing, and in what box of risk is this dealing with, and having everything else follow from that, but starting up front of that, you end up having to be forced at the front end to ask the question, where should this loss rightfully lay? And one answer may be, you've got a claim against your broker. who did not give you the right information, regardless of what the text is and whether we can agree or disagree on what the text is. It may be that. One answer may be, well, the policyholder just has to lump it. The loss is rightfully laid at that foot. One answer might be it goes to a tax-based system of Medicare, Medicaid, welfare, whatever. But at least asking the question, if it's not covered here, where does it go, we think is important. Not covering a loss doesn't mean the loss disappears for the policyholder. It's got to be spent somewhere else. And if it's the tax base or some other entity out there, we would just like to have that worked out at the front end.
I think we're going to transition to our final panel of the day, but let's thank